Good afternoon. I am Michael Greco, Chair of the American Bar Association Center for Human Rights. I regret that I'm unable to be with you in person today due to a trip to China this week, but I am pleased to support the efforts of Northeastern University School of Law, and especially Martha Davis and her colleagues, to examine an important topic in international human rights law today, the responsibilities of the business sector with respect to human rights. This subject received clear and compelling answers earlier this year in the form of newly adopted United Nations guiding principles on business and human rights, which were developed under the leadership of Professor John Ruggie. Appointed by Kofi Annan as Special Representative of the UN Secretary General on Human Rights in Transnational Corporations and Other Business Enterprises, Professor Ruggie in June 2008 submitted a report to the UN Human Rights Council entitled Protect, Respect, and Remedy, a Framework for Business and Human Rights. Professor Ruggie's report and framework led ultimately to the adoption of the guiding principles that will be discussed today in this webinar. In his report, Professor Ruggie determined that the root cause of today's business and human rights predicament are governance gaps caused by the rapid globalization of business, and that these governance gaps in turn have caused a permissive environment for the commission of wrongful acts by companies of all kinds without sanctioning or reparation. How to narrow and ultimately bridge the gaps in relation to human rights is our fundamental challenge, said Professor Ruggie in his report. In response to this challenge, the framework that Professor Ruggie and his colleagues developed in their report to the United Nations rests on three complementary pillars. The first pillar is the duty of the state to protect the human rights of its people. While this duty is well established in international law and custom, the focus in the framework is on how the state is to protect against human rights abuses by third parties, including business entities. The second pillar is the responsibility of business to protect human rights. While the responsibilities of corporations should not and cannot simply mirror the duties of states, the challenge is to define the duties of companies. The framework emphasizes the need in managing the human rights impacts of their operations and addresses the concept of legal complicity. The third pillar is the need for more effective access to remedies for human rights violations. State regulation proscribing corporate conduct that violates human rights will have little impact without accompanying mechanisms to investigate, punish, and redress abuses. States need to strengthen legal frameworks to hear complaints and enforce remedies against all corporations operating or based in their territory. In June 2008, the UN Human Rights Council welcomed, quote unquote, the framework report and renewed Special Representative Ruggie's term for 3 years in order to operationalize the framework through practical guiding principles. After conducting broad-based consultation as he had in developing the framework, Professor Ruggie submitted those guiding principles in March 2011, and the UN Human Rights Council endorsed them in June 2011. In August 2011, on the initiative and strong recommendation of the ABA Center for Human Rights, the 550-member ABA House of Delegates endorsed the framework and the guiding principles as official policy of the American Bar Association. As explained in Professor Ruggie's report, the importance of the guiding principles is not the creation of new international law obligations, but, quote, in elaborating the implications of existing standards and practice for states and businesses, integrating them within a single, logically coherent and comprehensive template, and identifying where the current regime falls short and how it should be improved, end quote. Importantly, the implications and application of the guiding principles to business are not the concern of corporate executives alone. of course, but of lawyers as well. In fact, the legal profession, including major law firms, was intimately involved in the development of the framework and the guiding principles, which are likely to influence legal regulations and processes. Corporations may find more clarity in standards and compliance requirements. States may step up investigation and enforcement, and individuals harmed by corporate activities may benefit from enhanced causes of action and access to justice. Indeed, for most businesses, the familiar precept of corporate social responsibility, or CSR, until now has been a voluntary, market-driven, and discretionary standard of conduct that varies greatly from company to company. The guiding principles, in contrast, constitute a baseline standard of conduct that applies to all businesses and law firms, whatever their size and wherever they operate. Further, ABA Model Rule of Professional Conduct 2.1 may well apply in this context. Rule 2.1 requires lawyers to exercise, quote, independent professional judgment and render candid advice, close quote, and permits them to, quote, refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation, close quote. This imperative logically would include applicable international standards in the conduct of a client's affairs, including the guiding principles, where corporate clients are concerned. And so there's much for you to discuss today regarding the implications of the guiding principles for lawyers, law firms, and the legal profession generally. I wish I were with you to participate in the discussion. But I look forward to watching the video of this webinar when I return from China, and to having the benefit of your wisdom as the ABA Center for Human Rights pursues implementation of the ABA's new policy endorsing the guiding principles. You have my best wishes.
Those of us that have been along for the ride. Now, most of that has been driven by scandals and growing capacities of different stakeholders to put pressure on corporations, and so you can go back and look at some things like Bhopal in India and Nike and the sweatshops. He was communicating was that the ethical duty of a lawyer is really largely wrapped up in the relationship with the client. And beyond that, any kind of ethical obligations towards society, I think, have been largely lost, at least on these discussions of the legal practice. So today we're going to break that wall down, I hope, And I think that John Ruggie's work and the guiding principles have given us a good impetus or a good framework to really push that debate. And I would say that there's really three ways that the work of John Ruggie and the guiding principles will affect the legal practice. On the one hand, lawyers have a big role in just helping with the implementation of all of the normative framing that John and his team have done over the years. And that's important, and the lawyers and law firms have been involved to date, but there's a wide world of work to be done around how do we design remedies to be more effective, and how do we design laws to be more effective in terms of these business and human rights issues. So there's a big, wide open field there for lawyers. Secondly, with respect to the advice that lawyers and law firms are giving to their clients. And third is this question that I was broaching earlier about what does this mean for the very practice of law firms and lawyers. So you have three big categories, and I think today we'll probably focus on the latter two, but it's worth just keeping all three in mind. Okay, with that, we're going to jump into our distinguished panel here, a panel of good friends of mine, which is really nice. I'll introduce them briefly. Their longer bios are on the web. I'm just going to give a couple quick points about these folks from what I've gathered over the years. John Sherman was a practicing attorney for most of his career with National Grid, if I'm not mistaken, John, and then turned to academia for a little while, and over at Harvard worked with John Ruggie very closely, part of his team, and has been a critical legal mind in helping John work there, and most recently has been one of the co-founders of an organization called SHIFT, which is, and I believe is the general counsel of SHIFT, and is taking forward through SHIFT providing advisory services and thought leadership around how companies and governments go about implementing these business and human rights norms. Sarah Altschuller, is a practicing attorney with Foley Hoag. They have their main offices here in Boston, I believe, but she practices down in D.C., where they have a thriving corporate social responsibility and business and human rights practice, probably the leading practice in the world, or at least amongst the top 2 or 3. And she has a very envious job where she doesn't have to practice these things on her pro bono side hours, but can do it 24/7, which is a real privilege, I think. And of course, she's earned that and does great work. She's also an avid blogger, and I get much of my news on business and human rights through her blog, so I highly recommend it. And then, of course, we have Martha Davis, who's a professor here at Northeastern Law School, a constitutional professor. She co-directs the program on human rights in the global economy, which is one of the leading program areas in terms of moving from that narrow range of civil and political rights, where most programs focus, to the broader issues of economic and social rights, and really looking at economics and the markets and how those affect human rights. So she co-directs that program. And she's a scholar on women's rights and human rights, and all of that, I think, will feed in well to the topics that we're going to face today. With that, I'm going to turn it over to John. He has 15 minutes. I'm going to try to keep it tight, and then afterwards we'll have plenty of time for dialogue.
Okay. Thank you, Chris, and good afternoon. My job today is to explain why the corporate responsibility to respect human rights, which is the second pillar of the protect, respect, and remedy framework that Mike Greco just described, matters to lawyers who advise businesses. And that's a subject of personal interest to me since I was a former deputy general counsel of a large U.S.-UK company. Afterwards, I became a member of John Ruggie's core team and helped to draft the guiding principles. So the short answer to this question of why it matters is that harming human rights is a risk that companies have to manage as a matter of good corporate governance. And lawyers and law firms who advise companies have a unique ability and indeed a responsibility under the guiding principles, and as Professor Davis will elaborate on, a professional responsibility to advise clients on how they can achieve their business goals without harming human rights. So let me get into it. Okay. Now, I need to give you some background on what the corporate responsibility to respect means. It's essentially a responsibility not to infringe on human rights, both through a company's own operations and through its business relationships. And it embodies the baseline steps that global society expects businesses to take. It draws on international conventions and treaties for its content, but it doesn't replace them. Instead, it provides process guidance on how companies can achieve their goals consistent with those international standards. Now, viewed from just a technically legal perspective, the responsibility to respect is soft law. But it doesn't exist in a law-free zone either, since many countries already legislate compliance with human rights standards in such areas as labor, safety, environment, anti-discrimination. But the corporate responsibility to respect applies worldwide in all countries, even where the law is absent or it's unenforced. And the scope of the responsibility to respect covers all internationally recognized human rights, not just a pre-selected few, because the research has shown that businesses can affect all of these rights. So, what is this standard? It's a knowing and showing standard that requires businesses to know and show that they're respecting human rights by adopting a management process that enables them to do so. And the first part is a top-level policy commitment by the highest level in the organization to respect human rights, which is supported by effective operational level policies such as training and incentive structures that embed the company's commitment to respect from the top of the organization all the way to the bottom. And then it requires a process of human rights due diligence. That's a dynamic management process that requires companies to take 4 specific steps. The first is to assess their actual and potential impacts on human rights, measured from the perspective of the stakeholder whose rights may be impacted. Second, it requires companies to take integrated and coordinated action to respond to and address these impacts. Third, it requires them to monitor the effectiveness of their performance. And fourth, to communicate their performance to affected stakeholders, including reporting as necessary. And last, there's a responsibility of companies to cooperate in legitimate processes, including non-judicial grievance mechanisms, to remedy human rights harms that they may have caused or contributed to. So that's the knowing and showing framework. Now, they've enjoyed wide uptake, and this chart has at the middle a picture, a smiling picture of Professor Ruggie. And I use it to show that governments, companies, investors, international standard-setting organizations, as well as civil society and their advocacy have reflected the guiding principles. A couple of examples: the OECD guidelines for multinational enterprises, the new International Standards Organization 26,000 on corporate social responsibility for companies, and the revised International Finance Committee Sustainability Framework and Performance Standards have all imported the Ruggie principles. And not least are the International Bar Association and the American Bar Association. In addition, governments, as you'll hear from Sarah later, are promulgating regulations and policies that incentivize and require companies to have the kinds of processes that enable them to respect human rights. One example is the European Commission, which is currently developing guidance on how industries can align their business with human rights, with the guiding principles. And then there's the new Association of Southeast Asian countries is conducting a baseline thematic study on business and human rights in that region. Now, why I'm interested in the responsibility to respect as a basic tool of corporate governance is that it's obvious to those who advise businesses that good corporate governance requires companies to, their boards and their executives, to manage their significant risks, and that includes their impacts on human rights. As Marty Lipton of Wachtell, Lipton, Rose and Katz recognized in a widely cited memo to his firm's clients a year or two ago. Enterprise risk management is a core feature of corporate governance standards that have found their way into hard law and soft law principles the world over, including the U.S., Canada, Europe, Japan, and many other countries. Now, despite the requirement, as a matter of corporate governance, that companies manage the risks of their external stakeholder impacts, they don't always appreciate the full scope of their risks. For example, very recently, community protests forced the suspension of construction of a $4.8 billion gold mine in the Cajamarca region of northern Peru, the so-called Conga mine. And as a result of the delay caused by the blockades of the plants and the protests, the plant's owners calculated a $2.1 million per day penalty initially. That's significant money. And this echoes the research of Professor Ruggie, who found in his 2010 report that extractive sector companies were not fully accounting for the costs of conflict with local communities, and therefore not properly managing them and not properly reporting them to their shareholders that arise from exploration and production activities. And those activities can have a huge potential for human rights impacts on local communities. And he has identified it in a 2008 study of 190 oil and gas projects, showing that the time to bring those projects online had doubled in 10 years, causing significant delay costs. And a follow-up study showed that non-technical risks accounted for more than half of the delay, and of that, external stakeholder risk constituted the largest category. However, calculating the full impact of community conflict is not a simple cost-benefit analysis for a company. It requires, as I said earlier, looking at the impact from the perspective of the affected stakeholders. And a critical feature of modern enterprise risk management is its focus on the company's need to identify, assess, and manage the impact of their business on external stakeholders. For example, in 2009, the International Standards Organization promulgated a global risk management standard called ISO 31000, and it provides that companies need to understand the risk of its impact on internal and external stakeholders and assess the tolerance of the risk that those stakeholders bear as a result of the company's actions. It isn't enough for companies to look at the negative impact of human rights solely from the company's perspective. To do so incorrectly assumes that potential victims have the same tolerance for negative human rights impacts as the company. That's wrong. That's the Ford Pinto fallacy, which says essentially the company's shareholders may be able to tolerate the economic consequences of a wrongful death suit from a poorly designed gas tank that explodes in a collision. But from the perspective of the family of the driver and the children who were killed in the accident, the consequences are intolerable. And that's the perspective from which a human rights impact must be assessed. Now, the guiding principles provide specific guidance on how companies should manage the risks of the most severe impact. Guiding principle 23C says that companies should treat the risks of causing or contributing to gross human rights abuses, such as torture, death, slavery, as a legal compliance wherever they operate, even if the applicable legal standard isn't clear. Now, I'm not going to talk about the Alien Tort Statute, whose application to corporations and whose extraterritorial reach is being considered by the U.S. Supreme Court in the Kyobo case, which alleges Shell's complicity in gross human rights abuses committed by the Nigerian military in the mid-90s. The ATS has been a significant legal tool for victims seeking to hold international companies legally accountable, but it's not the only game in town. In 2007, Professor Ruggie identified an expanding web of potential corporate liability for international crimes imposed by courts around the world. And in this very fluid setting, he concluded that laws of probability suggest that corporations will be subject to increased liability for international crimes in the future. Now, this guiding principle recognizes that regardless of the uncertainty of the law in a particular jurisdiction, a company's involvement in gross human rights abuses would be such a calamity for the company, for society, and for the individuals involved that its lawyers ought to be proactively engaged in preventing its occurrence, just as they would be engaged in the prevention of any serious corporate crime. Now, last, I want to address the emerging recognition that lawyers must advise their corporate clients on human rights risks. As I noted earlier, and as Mike Greco opened and Chris observed, the UN guiding principles apply to all businesses, public or private, large or small, and that includes law firms. The international legal community substantially supported Professor Ruggi's mandate, and increasingly, law firms like Foley Hoag are providing advice to their corporate clients on guiding principles. But as a group, law firms have lagged far behind other sectors in their ability to know and show that they're respecting human rights. They have very significant abilities to influence their clients' impacts on human rights, which is critically important to the response that they have to take under the guiding principles. Now, guiding principle 19b requires businesses to take appropriate actions to address adverse impacts on human rights in which they're involved not only through their own operations, but also through their business relationships. And that includes suppliers and joint venturers and major customers, and in the case of law firms, clients. Now, where a company is involved in a human rights impact solely because that impact is directly linked to the services it provides, and that means services provided by a law firm to a client, the company needs to exercise its leverage to influence its business relationship to mitigate or prevent that harm. And then if they're unsuccessful, they have to consider terminating the relationship, taking into account the severity of the impact and the effect of termination on human rights. Now, law firms, like any other business, can also be linked to human rights impacts for the services they render to their clients. And respecting human rights in this context requires a law firm to take a number of steps, including determining what the impact of its actions on human rights may be, influencing the client not to engage in future human rights harm, and if that doesn't work, determining whether or not to withdraw from the representation. Now, of course, these responsibilities under the guiding principles have to be squared with the professional ethical responsibilities of lawyers. In endorsing the guiding principles in February 2012, the American Bar Association has begun to address that issue in a positive way. But I'll let Professor Davis talk about that in more detail. Thank you.
Okay, wonderful, John. Thank you very much. We're now going to move to our next panelist, Sarah.
Thank you very much, Chris and John. And I will build on some of what John said and also what Mike Greco said in my remarks. Again, my name is Sarah Altschuller. I practice with corporate social responsibility practice at Foley Hoag. I've been with the practice for almost 9 years. I started in 2003. The last year, have been very privileged to have John Ruggi as a colleague. He has been a senior advisor to our practice since July 2011. And picking up on what John said, I'm not going to sort of rehash what the guiding principles are and why companies should care. What I want to talk to you about is how this has changed our advice to clients. We've been advising clients on human rights issues since the practice was started in 2000. And our advice has always consisted of advice on policy and standard development, human rights impact assessment, development of oversight mechanisms and tools, such as training, to help companies identify the human rights impacts of their operations and manage those impacts appropriately and responsibly. The core advice that we provide has not changed, but our advice has been put into a new context. And in thinking about why our clients have come to us in the past and the conversations that we've had, our advice has been about best practices in the field, whether it's in a particular industry. Maybe we're talking to a tech company about the Global Network Initiative, or an extractive company about the voluntary principles on security and human rights. We've always tried to figure out where do we engage this particular client on the subject of human rights. Frequently, legal risk has been an issue in our conversations with clients. Certainly, potential liability under the Alien Tort Statute, and as John mentioned, potential liability under a range of different statutes and regulations around the world. The guiding principle has in some ways made my job a lot easier in engaging corporate clients in these discussions. And I think Michael Greco mentioned, actually quoted this, and I want to note it again because it helps to put into context what has changed and what has not changed. Professor Reggie said last year, the guiding principle's normative contribution lies not in the creation of new international law obligations, but in elaborating the implications of existing standards and practices for states and businesses, integrating them within a single, logically coherent and comprehensive template. That single template, that baseline expectation, has been incredibly powerful in our ability to advise clients on these issues. I think it's important to recognize the fundamental human rights law obligations and what defines human rights have not changed. We're still talking about human rights as defined by the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and the ILO Conventions. Those still provide substantive definition of human rights. But prior to the emergence of the guiding principles, we had lots of scattered and varied conversations about what corporate responsibility was and what companies should do with regard to these documents. I graduated from law school 10 years ago, and I spent my last year in law school doing a large research paper looking at what companies were saying with regard to human rights. And I literally counted American companies who was referencing the Universal Declaration of Human Rights, who was in some ways holding themselves out as accountable, or at least saying that they were going to operate consistently with the principles set forward in this fundamental document. It was a relatively small number. I actually went back and read my research 10 years ago. And as a student, I was very interested in how do we tie companies to fundamental human rights laws. Spent a lot of time looking at the Alien Tort Statute, looking at liability. And this conversation carried through into my legal practice. Some clients just wanted to talk about liability. Some clients had certain needs to be out there demonstrating that they followed best practices. They had very strong codes of conduct. They wanted to be leaders in their industry. They were concerned about the reputation of key stakeholders. And we might be talking to the general counsel one day, to someone just, vice president of corporate social responsibility the other day, who may or may not have a particularly good internal conversation going with the general counsel. Someone in security. We had a very scattered and varied conversation. The emergence of the guiding principle as a single coherent template, as Professor Rugby referred to it, is allowing us to have a very different conversation. And it's helping us counteract some of the pushback that we've received in the past. Clients who wanted to be responsible in the area of human rights might say, well, there's too many standards. We don't know which, do we follow this standard, do we follow that standard? We're not sure what best practices would mean. Or, and this is something that I talk to a lot of companies about, if I was standing in front of an audience that hypothetically represented everyone in the company, and I started talking about human rights, I still sometimes feel, and I certainly used to feel, that approximately 95%, if not more, of the room would suddenly go, oh, she's talking about human rights that has nothing to do with me. it actually presents a very difficult challenge for those within the company who are trying to advance responsible practices, because many people in the company impact how the company may create adverse impacts, may prevent adverse impacts. Could be someone in occupational health and safety, could be someone in human resources. Having just a single template to talk about allows for a much simpler conversation. It's still a very difficult conversation to really, and a lot of companies are talking about how to integrate the guiding principles into their operations, but we at least have this baseline expectation. And again, not to reiterate, John Sherman covered this quite well, but again, sort of, what are we talking about in terms of these fundamental expectations of companies? At a very high level, corporate level policy commitments to respect human rights. Human rights impact assessments. Companies are being held accountable and responsible for identifying the human rights impacts of their operations and for seeking to prevent, mitigate, or avoid the adverse impacts. The integration of findings from those human rights impact assessments into their operations, and the development of effective grievance mechanisms and other remedies for those who have suffered adverse human rights impacts. Again, this is the sort of the core set of expectations that we're now talking about, and it is no longer just this is best practice. It's really becoming a conversation about this is what is expected. And it's not just, you know, another voluntary guideline. And again, not to completely go over what John Sherman talked about, but this is being integrated into standards, guidelines, and mandatory requirements that impact companies around the globe. The OECD guidelines for multinational enterprises now say that enterprises should respect human rights, avoid causing or contributing to adverse human rights impacts, seek ways to prevent or mitigate adverse human rights impacts, have a policy commitment to respect human rights, carry out human rights due diligence, and provide for or cooperate through legitimate processes in the remediation of adverse human rights impacts. Again, as John said, the IFC sustainability framework has emerged with similarly the same set of expectations. The ISO 26000, the same set of expectations. And these guidelines have also been incorporated and endorsed by, as Michael Greco said, the ABA, the European Commission, and the United States Council for International Business, among many others. So even within very skeptical corporate entities, this is starting to get attention. It's not just about who wants to be sort of leading on best practices or who has particular reputational concerns. These are standards that may be tied to corporate finance, may be informing conversations with business partners and stakeholders, may be embedded in vendor guidelines and joint venture agreements. And all of a sudden, this is becoming a fundamental part of how people are understanding their obligations to society and how lawyers should be advising clients on what the expectations of their behavior are, along both best practices and voluntary guidelines, but also real hardline expectations. Certainly, you know, the embedding in statutes and regulations is the way to get the attention of your general counsel and people in your traditional lawyers' offices. You know, in working with firms, with companies over the last 9 years, again, our internal client has sometimes been people in the general counsel's office, but very frequently human rights has been staffed somewhere else in the company. General counsel hasn't really touched the human rights issues. And suddenly we're finding ourselves engaged much more with the traditional lawyers inside the company because they see this is something they need to be paying attention to. And I see this as a fundamental role of any lawyer advising companies. Helping your client spot and understand where the law is going. Helping them understand what the expectations of their behavior are and what they will be tomorrow. And when I spoke at a conference about a month ago to an audience of general counsel. I was talking to many of them about the role of a general counsel of a big company. And certainly John can speak to this much better than I can, but many talked about, you know, you're trying to make sure you're in compliance with everything you need to be in compliance with. You're trying to manage your litigation strategy. You've got many different things going on. And it's very helpful to have someone out slightly removed sort of spotting trends and spotting what do you need to be paying attention to that is not right in front of your desk right now. And as John mentioned, enterprise risk management has become something a lot of companies are paying attention to, especially larger companies. And this is another important audience for legal advice in terms of where is the law going? What do you need to be doing? This is no longer just a conversation like I had 5 or 6 years ago where I felt like if I could tell a client I don't see a real risk of alien tort liability or other liability, some clients would say, okay, we're done. I'm not going to be held liable. Don't feel like we're in risk of being complicit with gross human rights abuses. I can almost see a sort of attention shifted elsewhere. Now we have much more of a proactive expectation of what companies need to be doing. And I want to talk about, again, advising clients on where the law is going, just how quickly that this is happening. And I'll talk about this purely in the context of the United States. And just a few examples. There were some unexpected surprises for those who are paying attention to the Dodd-Frank financial reform bill in 2010. Section 1502 on conflict minerals requires companies that utilize tin, tungsten, tantalum, and gold to conduct and disclose due diligence on their supply chains in order to identify whether the sourcing of those minerals is tied to the Democratic Republic of Congo and adjoining countries. Fundamentally ask companies to do due diligence in order to identify whether their sourcing is causing an adverse human rights impact. Now, for those who are looking at what the SEC is trying to do in implementing a rule around this legislation, it's very difficult. These challenges are situations like what's happening in the Congo are ever changing. Human rights is not a check-the-box compliance field, which makes it a particularly difficult challenge for some of the traditional SEC and securities layers. But I think watching this emerge in 2010, even before the emergence of the guiding principles, was its first sort of indication of even, Congress is looking at this. We're seeing this new expectation of companies emerge, and it's starting to show up in legislation. Another act that passed at the state level, the California Transparency and Supply Chains Act, went into effect in January of this year. And it applies to retail sellers and manufacturers doing business in California that have annual gross receipts exceeding $100 million. When I first started looking at the statute, it provided an interesting time for me to engage with some of our tax lawyers, because what it means to be doing business in California is actually not, it's actually a very low threshold. And it surprised a lot of companies. Suddenly this statute applied to them, and what the statute asked them to do was disclose what actions they were taking, if any, to evaluate and address the risks of human trafficking and slavery in their product supply chains, to conduct audits of their suppliers to evaluate compliance with company standards on trafficking and slavery, and that assumes that companies have standards on trafficking and human slavery, and to provide training to employees and managers with training on the mitigation of human trafficking and slavery risk. Again, this expectation that companies are going to be held accountable for what the adverse human rights impacts of their operations are. Now, both of these statutes are disclosure statutes. The federal statute is tied to the SEC, it's tied to the annual reports of companies. That raises some more significant concerns in terms of potential liability of inaccurate disclosures. The California statute is just asking companies to disclose on their website. But I think we're seeing at the beginning of a more powerful conversation that this is no longer sort of best practices to really understand your human rights impacts. You're going to be expected to do so. Two bills, and then I will conclude. Go back. Two bills in Congress that, again, I think are indicative of this new trend. H.R. 2759, the Business Transparency on Trafficking and Slavery Act. This was introduced last August, and it builds on the California statute. It's very much modeled on the California statute, but it actually applies to a broader range of potential human rights abuses, including child labor. But again, some of the same elements that you see in the human rights due diligence framework, asking companies to maintain policies, to engage in verification of their supply chains to identify risks of human forced labor, slavery, human trafficking. All of these expectations are just becoming a common converging set of expectations. And finally, the Global Online Freedom Act, which has been introduced through the last several Congresses, but asks Internet communication service companies to do due diligence on where their products are going, and to do so actually in a way that mirrors the OECD guidelines for multinational enterprises' expectations on human rights due diligence. So we're seeing, again, this convergence, which I think is powerful. It's something lawyers need to understand, and we need to help their clients understand. And with that, I'm happy to answer questions. I will conclude.
Great. Thank you so much, Sarah. And with that, we have our third panelist, Professor Martha Davis. Thank you, Martha.
Thanks, Chris. So since I'm the third panelist, I'm going to remind people about questions. So folks in the audience have cards. Please think about questions you want to ask the panelists and hand them up here. And I think one of the staff will come around to get questions. And folks who are online on the webinar, you can use the chat function to send questions in, and we'll relay them up to Chris to ask. So thank you very much for that. So I'm excited to be here to share the panel with this group of experts. I'm sort of a fish out of water since I don't practice business law, but I teach legal ethics. And what I want to offer are some specific ideas about how the guiding principles interact with the legal ethics rules to which all lawyers are subject. And because legal ethics rules vary from state to state, I'll refer to the American Bar Association's model rules on professional conduct, which I've got here. And at this point, the model rules serve as a model for virtually all of the state legal ethics codes across the country. And to cut to the chase, there's really just one basic point that I want to make, and that is, while the guiding principles themselves may be soft law for businesses, they're emerging as hard law for lawyers. And similar to the processes we've heard about, where OECD or governments adopt regulations, that's what's happening for lawyers in terms of the guiding principles. And I'll explain what I mean by referring to ABA Model Rule 2.1, which people have alluded to earlier. The ABA, in its resolution endorsing the guiding principles, specifically noted Model Rule 2.1. There's something notable about this rule and about the ABA's endorsement of the guiding principles. So, let's take it back to something. Okay, so we've got Rule 2.1 up there, and this is a rule that has exact counterparts in almost all state codes, though surprisingly not in California, which is a big important state. So keep that in mind. But if you're familiar with legal ethics codes, you know that some rules give lawyers broad discretion to determine, for example, when an exception to client confidence applies. And those rules are written in discretionary terms. A lawyer may reveal client confidences, for example, when he or she believes it's reasonably necessary to avoid greater harm specified by the rules, so death, or in Massachusetts, where we are here, wrongful incarceration of an individual may be an exemption to client confidence. But this rule, Rule 2.1, is written in the imperative, at least in part. It says the lawyer shall render candid advice and exercise professional judgment. So that seems like a basic criteria for legal advice. The rule then goes on in the second sentence to indicate that candid advice may include reference to moral, economic, social, and political standards. And now this is where I think the ABA's endorsement gets interesting. Referring to Rule 2.1, the ABA endorsement notes that, quote, this imperative logically would include applicable international standards in the conduct of a client's affairs, including the framework and guiding principles where corporate clients are concerned. So this reference to imperative clearly refers to the shall language of the rule, the first sentence. That's the imperative here. So the ABA's report suggests that reference to a knowledge of the guiding principles in the framework are part of the mandatory rendering of candid advice. The guiding principles are not simply moral, economic, social, political standards that may be shared with a client, but a component of candid legal advice that lawyers must render or violate our professional standards, with all that that implies. And of course, for the more general debate about whether human rights, this is particularly interesting because it's general wisdom that vis-a-vis businesses, general principles are so-called soft law. And of course, it's also interesting for the more general debate about whether human rights law is really law at all. But the ABA interpretation indicates that while the general principles might be soft law purposes, for purposes of the UN enforcement against businesses, they may be hard law for purposes of legal ethics and standards of legal advising. And this reading is consistent with the history of Rule 2.1, which, as originally proposed, made clear that the imperative portion of the rule, the first sentence, referred to legal advice, while the non-imperative portion, referring to moral considerations, in the second part of the rule, referred to non-legal advice. So importantly, the ABA is prepared to treat these guiding principles as law for purposes of the ethics rules. And I should add, of course, that there's nothing new about lawyers being subject to a different set of enforcement norms or hard law than their clients. Take the rules on solicitation, for example, or on advertising. So the guiding principles may be seen just as another one of the many areas where the hard law for lawyers is different than the hard law for clients. Still, if the guiding principles have the status of law for purposes of legal ethics rules, this has implications for other aspects of the rules as well. So, for example, let me see if I can get this one. Rule 1.1 on competence indicates that, quote, competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. The comments to the rule indicate that competence means inquiry into the factual and legal elements of the problem. And we know now that this may include, when appropriate, the guiding principles in their application. As law, the guiding principles are strongly incorporated into other ethics rules that set out legal standards for lawyers. So, for example, Rule 5.1 establishes that law firm partners shall make reasonable efforts to ensure that all lawyers in the firm conform to the rules of professional conduct, which includes compliance with the mandated Rule 2.1. So the implication of the language in the ABA's endorsement of general principles seems to be quite an important step. And in taking this step towards incorporating human rights standards into legal ethics codes, the ABA has moved towards joining other bars around the world. The European Bar's Code of Conduct in the European Community embraces human rights in its preamble as a goal of ethical lawyering. And Japan's basic rules on the duties of practicing attorneys addresses human rights directly, providing that, quote, an attorney shall be aware that his or her basic mission is to protect fundamental human rights, and then it goes on to say, and realize social justice, and shall strive to attain this mission. The ABA's endorsement and tentative incorporation of the guidelines of the law under Rule 2.1 is more limited than the European and Japanese codes, but at the same time it's more operationalized. This is not in the ABA endorsement hortatory language in the preamble. It's specific language connected to a specific human rights document, the guiding principles. And that's also one of the things that distinguishes our U.S. legal ethics rules from the many codes around the world. Not all, but many of them. Ours is really a working code with very specific guidance on real-world issues. And that's the way in which the guiding principles have been incorporated into our code. So let me raise the final question that others have alluded to, one that John Sherman has taken a lead on in exploring in other settings, and that's what do the guiding principles mean for law firms as businesses in their own right? The guidelines are clear that they apply to, quote, all businesses, whatever their sector, whatever their size, and wherever they operate. So there's not very much wiggle room there. And indeed, the American Bar Association acknowledged this broad applicability in its endorsement, while stopping short of exploring the implications of the guidelines for law firms and businesses themselves. A very few firms have taken this issue up and have implemented internal due diligence procedures of the same kinds that they are called to recommend for their clients, that their clients develop and that the guidelines describe. And this is set out in more detail in the report by Schiff that's available in the web materials for this program. In this area, though, the area of law firms as businesses, lawyers may be on a par with clients. The U.S. legal ethics codes do not provide the same level of guidance on law firm management as they do on issues of representation and advice. So it's harder to say that the guiding principles form a hard law that law firms must abide by. They can be a baseline, something that law firms have to deal with the risk of, but maybe not something that's so clearly hard law. But that's not to say that such a shift would be beyond the scope of the law governing lawyers. And as I wrote this, I realized that I say shift, maybe that's why you chose that name, since that's the name of John Sherman's organization. And again, comparative examples are instructive. The Canadian Bar Association Code of Professional Conduct, for example, does incorporate human rights norms into an aspect of law firm governance by incorporating human rights standards into standards of non-discrimination to which law firms are subject. So Canadian lawyers are held to non-discrimination standards that may be distinct from those in domestic law, but that are human rights standards. And one can imagine a similar shift in the law governing lawyers in the U.S., transforming the guiding principles into hard law for purposes of law firm practice, as well as for purposes of client representation and advice. So to sum up, I think this final issue that we've been sort of touching on throughout the presentation underscores the opportunity that the guiding principles create for lawyers that has yet to be fully taken up. And that is, the guiding principles provide a mechanism through which to claim a role for lawyers as more than technicians and advisors, and instead as public citizens, and as partners with businesses and governments in securing human rights. Thank you.
That's wonderful. Thank you, Martha. So I want to remind everyone, if you have a question, if you're online, please send it through your chat function, and if you're here in the audience, please write it down on one of those index cards, and someone will come and pick it up. We already do have a few questions, but before we jump into the audience participation part of this event, I want to do a very quick summary of what we heard just now. It'll take only a minute, and then I have a question myself, and we'll start with that, I think. What I heard was a very fluid overview between the three panelists. John started out talking about why human rights are so essential to corporations, what has brought them to the fore in a sense, and he talked a bit about, coming based on his personal experience working with John Ravi, about what the guiding principles require of companies, and touched on a little bit what they might require of law firms. Sarah then went a little bit further and talked about the sort of advice that she has traditionally been giving to companies and how the world around her has changed, making her role, I would say, more important and maybe a little bit easier because there's a more coherent framework now to delve into those questions. And she also touched on a little bit of the challenges that she faces in trying to advise companies with respect to their human rights obligations. And she finished off talking about where the law is headed and cited some very interesting U.S. statutes, both at the federal and state level, just underscoring the importance of these issues. Whether companies are ready or not, they will be forced to take some of these issues into account. That seems pretty clear. And then Martha really got into the weeds a little bit, in particular around the ABA's professional code and the Rule 2.1, and what the implications of that rule are with respect to the type of advice that lawyers and law firms provide to their companies and how they are almost mandated or required to start thinking about these broader human rights and social issues in the sort of advice that they give to clients, and talked a little bit more about what a practice based on a broader understanding of that rule might look like, and cited a few provisions from other countries. Good. So that was, I think, a very good overview, and I'm grateful to the panelists for really getting us to this point. And I hope that in the next 20 or 25 minutes we can dig in a little deeper. To that end, I'm going to put John and Sarah on the spot, and Martha, you're going to jump in as well. John, you work for a group called Shift.
Yes.
You are out there providing advice to companies. Okay. If Foley Hoag came to you and said, John, we want to contract your organization, tell us what we need to do to be not only compliant, but really best practice around the guiding principles, what would you tell her in just a minute or two?
Sure.
And where do you think she might be falling down and really needs to get on the ball? Personifying the term.
I think the first thing I would say is you need to have a top-level commitment, public commitment by the law firm to respect human rights. And then and I'm not going to go into dealing with your employees and your vendors because I think that that's similar to other companies. But you need to adopt a policy of client engagement, a policy through which you can engage your clients and find out what it is that they're doing and what the impacts on human rights may be, so that, and communicate that up front, so that when there comes to be a problem later on, you don't have to create an issue and explain things. Then you have to address what you would do under the circumstances where a client may become involved in a potential human rights issue. And you need to discuss that up front. And it's a very complex issue, and you should be discussing the kinds of things that would be of importance to you. I think you need to wrestle with the issue of transparency in reporting. That is a very vexing issue for law firms because there is a high social value to the attorney-client privilege. And you need to grapple with finding ways in which you can report on how you address your responsibilities. And so I think that in a nutshell are the core issues that I would address.
Okay. Martha, if I can put you on the spot now. I want you to be part of John's teamship. How are you going to underscore the importance that Foley, Hoag, and other firms like it take John's recommendations? Why should they even listen to John?
Yeah. Well, I mean, I guess goes back maybe to the point that I was making, that I think this is really a profession-wide commitment that's been made now. And the sorts of things that I would want to start seeing are reinforcement from a lot of different sectors, right? So there should be a continuing legal education requirement that these lawyers are subject to, that requires that they think and learn more about their obligations under the guiding principles of the human rights law generally. And to back it up even further, this should have been something that they learned at law school in their mandatory legal ethics class, which everyone has to take, and in the preparation for the NPRE, so that this isn't something that they're coming to, midstream. So that's the kind of, I think, reinforcement that I want to try to put into the mix.
And we know that students and recent graduates drove a lot of the pro bono interest of firms because it's such a key part of recruitment. Do you expect that students and recent grads will drive these sort of issues in firms as well?
That's a good point. I think they will if they know about it. So it's incumbent on us to have these kinds of programs and make sure that people are aware of the way in which this interacts not only with sweatshop businesses, but also with domestic law firms that people may be working at.
Right. So now, turning over to you, Sarah, if I hear Martha, she's saying not only are you going to start hearing questions about pro bono, but you might still hear questions about are you ruggy-proof as a firm. So I want to know, what is your response to John and Martha about where you hear them, but you think it's going to be difficult, or where you hear them and yes, those are the types of things that we could take on at Foley?
Sure. I'll take, having not been an executive committee or a managing partner yet, let me.
All hypothetical.
Exactly. I think we'll talk about some of the things that, the conversations that are happening. And again, our firm is in somewhat of a different position because the sort of business and human rights practice has been at the firm for 12 years. But I think as the guiding principles come out, in terms of really engaging within the firm around the guiding principles, it provided some ability to have conversations with lawyers who have never thought about human rights in the context of their advice to clients, about what their clients might need to be thinking about. And we've been able to approach new attorneys within our own firm and other clients to start having some of these conversations about human rights. Your point on CLE was very interesting. It's part of the conversation that I've had within the firm of, I can't go to a DC bar education class right now and sort of get up to speed on that. And to the firm's credit, they've been supportive of, okay, what conferences should we be sending associates to? What meetings do they need to be attending to really hear the conversations and learn about what's going on? That has been somewhat easier, and certainly Professor Ruggi's presence as an advisor to our Boston office has engaged a new set of lawyers within the firm about the guiding principles and what the implications are. The harder level conversation and what I would certainly say this conversation is happening within the firm or within parts of the firm. The big picture top-level policy. What does that mean? How does that change how the law firm sees itself and one's role? And there is conversation about that happening, but I think it's a much more difficult conversation. I think the internal engagement, both with other lawyers and with clients, is happening, and is something that is a more comfortable conversation than how do we make a high-level public transparent commitment.
Great. Thank you for bearing with that. I'm now going to take some of the questions that we've been getting online and through the audience, and because there's so many of them, I'm going to do my best to combine them into a couple of broad questions, and I'm going to put them to the panel generally, but don't feel obligated, all three of you, to respond. It's fine if just one of you happens to respond to them, because we have only 15 minutes. My first question is, what do we consider to be the key drivers for moving this discussion forward around the guiding principles? Or to reframe it, why are companies going to stand up and take notice of this? Is it because the risks to doing it are becoming more and more evident? Or is it because there are opportunities in the way that we've seen the environmental practices move forward because of all the opportunities to save money? Are you optimistic? Are you, in fact, seeing over the last year since the UN endorsed the guiding principles, are we seeing an uptick in corporate responsiveness to these issues? Who's going to take that one on? John, first hand, okay.
You can start. I think the answer is yes to all of them. Risks are becoming clearer, and one of the there's a complementarity to the first pillar, the duty to protect, and the corporate responsibility to respect. And it comes out of this whole concept of that you've heard in lawyers have heard in another context of bargaining in the shadow of the law. People don't go, divorces are less litigated less because the lawyers know what the rules are. As rules, law, hard law, administrative law becomes clearer through mechanisms that Sarah has outlined, then parties begin to engage in non-litigious behavior to try to resolve problems. So I think that the effective convergence of the imposition of legal standards in a lot of different areas drives people to bargain. At the same time, I mean act proactively. At the same time, standards that are set by that are agreed to by consensus globally and incorporated in multi-stakeholder institutions have a habit of concretizing into hard law. I mean, for example, I'll give you one example. The U.S. sentencing guidelines was a standard that was created by Congress to enable companies to develop a due diligence program, not mandatory. They wanted to avoid the problems of being sentenced more harshly. And what happened with that is that this rather narrow, non-mandatory rule was converted by the Delaware Chancery Court in the famous Caremark opinion in 2004 to become the fiduciary duty that corporate boards owe their shareholders to prevent corporate crime. It doesn't take too much imagination to think that if global society has said businesses must respect human rights, that will ultimately be determined at some point by a court to reflect a hard-line obligation. So you see convergence coming from two directions.
Yes, thank you, John. I want to just follow up on my question, though, on the positive side. Can either Martha or Sarah imagine a company actually deriving positive benefits and not just, again, mitigating risks? So certainly there are risks to be mitigated, and that has been the primary driver. But do we see anything comparable to the environmental side with restricted human rights? Any low-hanging fruit for companies, or any examples of that?
I think there's certainly been, and working in the field of corporate social responsibility, I mean, one of the challenges of working in the field is it means a lot of things to a lot of people. But I think you have seen a lot of discussion about creating shared value and what companies can be doing to both bring value and bring development to the communities in which they're operating. And I think the guiding principles add context to that discussion in terms of human rights, impact of companies' operations, and the ability to improve the situation of companies, of communities on the ground. I also, in opportunities, and John alluded to this, and it's something that I've been thinking a lot about recently, the first two pillars, this clarification of government responsibility and corporate responsibility, creates the possibilities for new synergies, and I'm seeing this in the context of a number of multi-stakeholder initiatives where there's a lot more focus about, okay, what are your responsibilities as a company, what are the governments need to be doing, and how can we be coordinating? And as you know, and for instance, the voluntary principles on security and human rights, there's much more focus on what do government actors need to be doing in certain host countries to support their companies that are operating there. How can they be engaging with host governments alongside companies to improve security and human rights, or mitigate the potential for adverse security and human rights situations? I just came back from the technology sector conference, and there was a similar conversation about if you have big telecommunications companies operating around the world that suddenly get requests for user data or get requests to shut down the internet, how can the home governments of those companies be engaged as partners in pushing back on some of those? And that clarification of responsibilities, I do think offers new opportunity.
Good, thank you. Did you want to add anything to that?
Yeah, well, actually, I mean, maybe I had almost a question, which is, I immediately went to sort of the law firm, the organizational issue, and issues of retention and hiring and that kind of thing. So do you, Sarah and John, who work in this field, do you see that as a positive component of this as well? It seems to me that to the extent that business has a sort of a mission-driven component, that's going to promote loyalty.
I think I see that both from the what clients say in terms of how a solid reputation in terms of being proactive in this area helps them retain key talent. Certainly see it in terms of the interest of law students right now finding legal jobs in this area. It's a dynamic, exciting area to work.
I thought of one positive area, if I could just add. My colleague at SHIP, Rachel Davis, who is also a key advisor to John Ruggie, did a study in the extractive industry of the cost of conflict. One of the most overlooked areas of costs was lost opportunities. When a company's top management is spending 90% of its time trying to address a human rights, environmental, social problem on an asset in the country that represents 5% of its investment, it's not taking into account, it's not able to capitalize on its opportunities to grow. That's a huge risk. It's not easy to quantify, but it is the most overlooked. And that goes directly to your point of why you should care about human rights. It allows you to do something better.
Great, thank you. Okay, we're going to shift now to, sorry. It's a great name. Actually, on that point, I thought we might get to a panel without the use of the word shared value. Thank you, Sarah, for bringing that up. There's one very narrow but interesting aspect of this discussion that's been touched on, but I wonder if one of you could suss it out a little bit. And it came up recently, I think, well, it's come up in a number of cases, so I won't give it as an anecdote, but rather, could you imagine a law firm, because of their compliance, let's say, or their interest in complying with guiding principles, actually starting to look at their clients through a human rights lens and saying these type of clients are simply too problematic because of the human rights impact that we think they're having, and we don't want to be involved in facilitating those human rights impacts. Could you actually imagine firms doing that? And could you imagine the ABA professional rules in some way endorsing or promoting that in order to be compliant. And along those lines, could you imagine actually firms terminating their representation because they think this turns out to be something we're just not comfortable with? So now I'm talking mainstream firms, not the little boutique progressive practice, but mainstream Wall Street firms. Can you imagine it? And if not, why not?
Sure. It's certainly, I mean, I'd be interested in hearing the practitioners talk about it. It's certainly consistent with the rules that that can happen. You know, lawyers have an obligation to provide this advice on human rights, that if they find that a client is persisting in ignoring it, lawyers have the ability to withdraw if they feel that a client is acting in a way that's morally reprehensible. And so it's certainly consistent with the rules. Now, whether I'll be interested to hear from folks that are in practice the extent to which that conversation is actually occurring. You know, whether you've reached that point of you know, decision making.
Right, because it certainly flies in the face of the idea that every person, dictator, criminal, gets their day with a good lawyer, right? So how do we manage that tension, John?
Here's the issue. There's a couple of issues. One is, how do you know what your client is doing? I mean, it is typical to be asked, particularly law firms nowadays that provide highly commoditized services, basically to pay for a deal. And the opportunity for them to conduct extensive due diligence on the client's dime is a difficult conversation to have. So I think that's one obstacle, and that's where a policy, an upfront policy is very helpful. The second issue is the one of termination. It's been done before. One can think of one law firm, one major U.S. law firm that was forced to, that elected, to terminate its involvement in an attempt to enforce the Defense of Marriage Act because that offended lesbian and gay lawyers, which it had supported. The trouble with that is that the termination typically requires avoidance of prejudice to the client, and there are some circumstances where when you get so deeply involved in a client relationship that it is impossible for you to terminate without it. So, yeah, these are theoretical issues. They're very hard to deal with in the abstract, in practice.
And of course, the ethics rules also make clear that lawyers are not held responsible for views. So if you can represent a rapist without having that be tarring your own, status. Right. So that goes to, I guess, your question. If you're in a situation where you can't withdraw, the court won't let you withdraw or something like that, you're not necessarily culpable for the client's activities.
The tougher issue is litigation. That's the tough one. You're zealous advocates. So where do when you're in court, as I've been, you're expected to go fight as hard as you can within the rules. And that's the one that's giving you the most difficult problems here. But I think even within that context, a litigator is advising his or her client every step of the way. You settle, do you not settle, what's the approach. So even in that context, you're confronted with Rule 2.1. You have to provide that to them.
And then you've got another question: the client just doesn't take your advice. Right. You're providing it again and again. The client's not following your advice. It's not a healthy relationship.
So, Sarah, anything more on this?
No, absolutely. And I think, I think of what I've seen in our firm and what I've seen and anecdotes from other firms. I mean, some of this happens a bit informally. There are things we would not seek out, types of work we would not agree to do. And certainly, actually, in the context of a CSR practice, we've had that conversation because, if the client's going to come to us with clearly a bad actor that is basically looking for sort of defensive cover-up, we've had the conversation that that's not the type of work that we want to be engaged in. And I think when you talk about, can you imagine firms not taking certain types of clients? even when I was graduating from law school, some firms had a reputation they didn't represent big tobacco, or they didn't represent, other types of industries, or it almost gets actually easier on the industry front than on the specific client. And I think some of John's points in terms of how much can you know? Our clients range from large multinationals to sovereign governments. There's a lot. These issues are tricky, especially as John said, in the litigation context, which again our practice is not involved in. But I see that throughout the firm. Of you represent your client to the best of your ability. It's easier, I think, to begin to make some informal choices about work you will not seek out, or work you will let phase out. We're not going to pursue particular type more work from the client if we've sort of grown uncomfortable.
Right. So it wouldn't be quite as hard as a go or no go. Okay, I think we have time for one last question. We have to be quick on it, so I'm going to take a combined question from all of the inputs I've gotten, and thank everybody for sending up your wonderful questions. If we didn't get to them, I hope you will follow up with John at SHIP, Sarah at Foley Hoag, and Professor Davis here at this law school. I'm sure their emails are easily sourced on Google. So the final question. You know that the Alien Tort Claims Act, or the Alien Tort Statute, is on the rocks right now. The Supreme Court looks like they want to actually do away, basically, with the statute, and we'll be hearing re-arguments of it shortly. If we see movement on that front in let's say, a negative way, what other prospects are there for holding U.S. headquartered companies, or any companies, accountable for human rights violations under law? And I guess don't focus too much on the ATS, but rather, are companies really facing legal liability for these human rights issues, or is it really just at the margins that a company might be subject to some kind of legal action, especially now with the Alien Tort Claims Act being pushed aside? Anyone want to take that one?
I think there are certainly other legal options, and some of even the alien tort cases, where the alien tort part of the case is constructed, you proceed under basic tort law, and there's other jurisdictions where statutes exist to bring both civil and criminal claims that have been done in countries around the world. Sanctions are another area. Looking at, for example, the new executive order imposing sanctions on companies that sell telecommunications equipment to Iran and Syria. It's quite interesting. Part of what was interesting there was the language, products that are likely to be used in a certain way. That likely to be used put a burden on companies to really identify and look at their customers. So I think there are other options.
I would just add, sometimes you wish for a result and you're not happy with what you get. And I think about the litigation against Chevron in Ecuador. Initially, Chevron resisted efforts to have the case tried in the United States courts and was successful. Great, because they thought they'd get a better result in Ecuador. Well, surprised, they didn't. They got an $8 billion judgment against them. Okay, that case has, as you've written, many aspects of human rights issues, and I don't know how it was initially framed. But the fact that you can get a huge judgment in a foreign country that then can be enforced in the United States, I think suggests to me that where there has been a sufficiently egregious harm, lawyers will find a way, whether it's in the United States or elsewhere.
Martha, are we trending towards more legal accountability, or are you pessimistic?
I'm always optimistic. So, and maybe actually I see Emily, so maybe we should end it on that note. But I think, what Sarah's hearing from law students, what we're, the fact that we're talking about this, the culmination, the gelling of the guiding principles, all of us are going to continue to push this.
Wonderful. Great. Well, thank you so much. Thank you to
And thank all of you and those of you who watched. And the work at Northeastern and the work at Oxfam and SHIP and Foley will continue. And I have to say, I personally agree with Martha that we've come a long way in the last 10 or 15 years, and that the progress will continue. So thank you very much, and continue the conversation offline.